good morning or good afternoon, everyone. Depends on where you're located now. So welcome to the fifth webinar of the project Edify Edu. And the fifth webinar is dedicated to the topic Understanding Legal and Regulatory Frameworks for EDI and Digital Practices. My name is, by the way, Val Racheva. I will be moderating this session today with our invited speaker. And I'm also also the part of the project. And I'm the team of one of the project partners in Germany. And today we invited our expert, whose name is Anne-Michèle Goris, and she's the founder at Privacy Power, a legal counsel and also external DPO and board advisor. I would love to shortly introduce her background. So besides being a founder of the Privacy Power Consulting, she's legal counsel specializing in privacy and GDPR compliance and also AI regulations. Anne-Michèle holds a master's degree in international business law from King's College London, and she has a background at international law firms, so she worked in international law firms. Besides that, she has extensive experience as external data protector officer, and she's been advising tech startups and global corporations on privacy strategies and regulatory compliance. Anne-Michèle combines legal expertise with entrepreneurial mindset, and with her work, she delivers tailored solutions and has a strong track record in public speaking, also in training and advisory roles. So welcome, Anne-Michèle. And today, specifically, because she is more an expert in GDPR, so she will cover today the area which is related to GDPR and EDI in practice, and she will introduce different case studies and give us insights what regards GDPR and also GDPR in relation to EDI. Welcome, Anne-Michèle, and the stage is yours. I'm gonna stop my screen sharing so you can start screen sharing your presentation. Right after Anna's presentation, you're welcome to ask questions to join the discussion round.
Thanks, Alva. I appreciate the nice introduction. Okay, I will go to sharing my screen. There we are. You should normally be seeing now the title slides. Is that correct?
Yeah, we see that. Yeah.
Okay, perfect. So hello, good morning, good afternoon, everyone. Welcome to this webinar, during which we will discuss as well explain the interaction between GDPR and EDI with a few use cases. Since we will be working with some use cases, I would really love for this to be a bit of an interactive session. So I'll ask you some questions, and you're welcome to answer them through the chat function. But before we move into this, Belle already gave a very nice introduction, so I'm not going to go very much deeper into this, but I'll briefly introduce myself. As well said, my name is Anne-Michèle. I am originally from Belgium. I currently live in Berlin. I started my career as a lawyer around 10 years ago, and then started my own business, Privacy Power, a few years ago, with which we offer consulting services to companies on GDPR and AI compliance. So yeah, now that you know who's standing in front of you, I would really like to know who I'm speaking to. So I would love for you to share with me where everyone is located. If you want to share it in the chat, I would really love to know where you're all dialing in from in this meeting. Let me know. All right, we have Finland. That's great. Hello. Anyone else who want to share where they're sitting? Helsinki. Hello. Colombia, Berlin, Dublin. Love it. That's great. Obviously, this information will not be stored. This is all GDPR compliant. All right. Albanian studying in Italy, Greece, Finland as well. Okay, okay. Armenia, Yerevan. Okay. Okay, great. Cool. Fantastic. Nice to meet you all. We will have some time at the end of the webinar for some questions if you have any. But if you have any really pressing questions with the cases, you're welcome to also, unmute yourself. I will also check the chats regularly, so we will have plenty of opportunities to discuss some questions if you have any. Let's dive into this. Let's go for it. I've seen in your materials that you've seen the key principles of GDPR, so we'll just quickly go over these as a kind of a reminder. One of the key principles of GDPR is lawfulness, fairness, and transparency. Lawfulness refers to the legal basis, right? You need a legal basis in order to process data, so you can have consent, legitimate interest, necessary for your contract. You need to have a legal basis, otherwise you cannot process data. And then we have obviously transparency, very important one, refers to obligation of being transparent. People need to know how you're processing their data, why you're doing it. And this obligation is usually performed through the publication of a privacy notice. Purpose limitation refers to the fact that you can only process data if you have a specified, explicit, and a legitimate purpose, right? You cannot use data for any further purpose that are incompatible with this original purpose. So you need to really make sure that you stay within the purpose for which you originally obtain the data and process the data. So let's say, when you receive data for, let's say, HR data or HR purposes, you cannot use this data for a random different purpose, right? You have to keep it within that purpose. That's what purpose limitation is about. Data minimization, the idea there is less is more. Don't collect or store or process data in any way that is not necessary in relation to the purpose for which they are processed, data minimization. Accuracy refers to the fact you have to keep your data accurate, up to date. Storage limitation means you shouldn't keep any data any longer than is necessary. Delete data as soon as you don't need it anymore. Think about, at which point can I not explain anymore why I still have this information, and then at that point delete it. Storage limitation is also the reason why companies keeping data indefinitely is in most cases not compatible with GDPR, because there are very few cases, if any, in which you can actually justify that a company needs to keep data for an indefinite period of time. So this is storage limitation. Then you have integrity and confidentiality, refers to the security measures that must put in place in order to protect the data. You need to make sure that it's safely and securely stored and processed. You need to protect it against hackers, against data breaches. They happen much more often than people imagine, or than people also want to admit sometimes. So it's definitely a very important one when it comes to protecting your data. And it also refers to the fact that you need to store the data confidentially, meaning the access should be organized on a need-to-know basis, meaning that only people who need access to the data should also have this access, right? For example, if you have a backend database with all the data from all of your customers, which sometimes is necessary, you shouldn't give access to this backend database with all the data to every single employee of your company. No, not everyone needs to have access to this database, and so not everyone should also receive that access. Sorry. Same also as, you're not going to be sharing any kind of information, any kind of personal data with your partner, your friends. This data needs to be treated confidentially. And then we go to accountability. Accountability is the company's obligation to basically show the fact that they can fulfill all these obligations, all these key principles that we have discussed. So that's accountability. So yeah, so we've been through the key principles. Let's now move into the cases. and we will apply those key principles to the cases. The first case is about a recruitment situation, which is very important in EDI. We'll definitely always, there's often going to be some EDI involved in it. I'll quickly read it to you. So the scenario is a tech company using an AI-based recruitment tool, which processes candidate data, including demographic information, to identify the best fits for open positions. Candidates discovered that their application was rejected, and a data subject access request revealed the AI used gender and ethnicity data to make decisions. So, thinking about the principles we just discussed, which ones do you think are the most problematic in this use case? You're welcome to write them in the chat. I would love to hear from you which ones you think are the most problematic ones. And we'll focus on the principles only, right? There are other topics, there's also AI here, but principles, which ones do you think are the most problematic ones? Let me know. I'll give you a minute to think about it. Anyone has an idea? We talked about lawfulness, transparency. We talked about the purpose limitation. All right. I'll give a few. Oh, you want to say something?
Yeah, because I heard a lot of cases when companies use AI for recruiting, and then it turned out that AI usually have a lot of biases, because they were actually, most of the AI kind of created or programmed by IT people, and IT people kind of a male mostly, right? So they probably could not, sometimes they kind of do not see that there is some biases in AI, right? And also because like our world was so biased in the past decades, and the AI is trained so much on this data, so it replicates more bias in recruiting, right?
Yeah, absolutely. And that is one of the main topics. Sorry?
And I think someone wanted to ask a question, Rosanna. Someone just showed up and then disappeared. I don't know.
Yeah.
I just wanted to see the slide again in order to figure out for the situation.
Here
The
it is.
slide for principles, I asked. Thank you.
Yeah, you're welcome.
Yeah, I'm just reading one of the comments. It says from one of the participants, and one of the participants writing, information shared with the AI should not include I think it was EDI, the information only experience and education. Yeah. No gender or racial, I think, information or anything of that background or age. Right.
Yeah, exactly. So that's a good point. So we talk, one of the main problems we here see is indeed data minimization. Is there a need to share this kind of information with AI? But the question is also, is there a need to collect this kind of information, this kind of gender and ethnicity data, to make a decision on whether a person is the best fit for a certain position? The answer for me is obviously no. So that's indeed one of the topics which is definitely problematic in this case, is the data minimization. I'll go through a few other ones that I see are problematic, right? Transparency. We read here, the candidate discovers that the application was rejected, and it's due to because of the data subject access request that this person realized or learned that this kind of information was used to make decisions, which shows for me that the person was not informed about the fact that this kind of information would be used. So clearly there's also a lack of transparency. But mainly, what for me is almost the most important one is the lawfulness, right? Gender, ethnicity data, this is sensitive personal data. Gender as such, not always. So gender is typically not a sensitive personal data, although some authorities have said that gender could give an indication of sexual preference, which again is sensitive personal data. So that's a bit of a side note. But ethnicity data, in any case, is sensitive personal data. And we went through the different legal bases that are required to process data, of which you have consent, legitimate interest. For sensitive personal data, the threshold of this legal basis is a bit higher to achieve. And consent will usually be the one or the most appropriate legal basis used for processing sensitive personal data. And obviously, in this case, there was no consent obtained. So those are for me the three main problems that I identify in this case when it comes to GDPR and respecting the privacy of the person who is applying for the position. In Finland, there was a case which highlights a bit of a different aspect of these key principles, but also within the same context of a recruitment case. What happened in Finland in 2024, so it's still this year, so a data subject, a person, asked a company to delete their data relating to the recruitment process that the person went through. The person was rejected, and the company refused to delete their data. Basically, the company said that they had a legal obligation to keep the data for 2 years after the end of the recruitment process. And on top of those 2 years, mandatory retention periods, the company said that they kept the data for an additional 6 months after the termination of those 2 years as a precautionary measure, which, from a company point of view, it's relatively understandable, actually. The data subject did not agree with this, filed a complaint with the Finnish Data Protection Authority, who then investigated the case. They confirmed that the 2-year retention period is indeed a legal obligation. So the company was, obliged to keep the data for that period of time. However, the Data Protection Authority said that the company was not allowed to keep the data for the additional 6 months. So the company was informed or instructed to delete the data. And why this is a bit of a different, aspect than the other ones. Here we're talking mostly about the retention periods, the fact that companies need to comply with retention periods. And especially in a recruitment situation, recruitment HR related processing, very often companies are obliged to keep data for a certain period of time. And so here, what is highlighted by this case is that it's very important to really respect that deadline, to keep the information for that period of time, but also not go over it. So you really have to fulfill your obligation, and don't do less, don't do more, just do exactly what is mandatory, what is required by the legislation. So that was for the first case. We will go to the second case. The second case is about employee diversity monitoring, also something which is quite relevant in a DEI situation. I will read the scenario. A multinational corporation implements a program to promote workplace diversity. To track progress, they collect employees' demographic data, such as ethnicity, gender identity, and sexual orientation. Some employees feel uneasy about sharing this information, and there are concerns about how the data is stored and used. I can go back to the principles. Let me know, what do you think is problematic? They are doing a diversity. Right, it's my paper here. Which of the principles do you think are problematic? I'll give you a minute. All right. Confidentiality. Data minimization. Okay. Purpose limitation. All right, great. Confidentiality as well. Okay, thanks. Those are all great answers. The first one I see is transparency. In the last sentence, we see there are concerns about how the data is stored and used. So clearly, the employees do not really understand what's going on. They don't have the full picture of what's going to happen with this information. They don't know how there are concerns about how it's done. So transparency for me is a big topic, which is problematic. Accuracy, I see that. Yeah. Okay, great. Then the second is indeed data minimization. It was mentioned because, right, we're looking at an employee diversity monitoring. If you look at the types of data the company is processing, in this case, ethnicity, gender identity, sexual orientation, do you think all of these types of data are really necessary to achieve the EDI purpose of the company to do this diversity monitoring? Is all the information really relevant, to understand the diversity of your company? Is it, for example, relevant for a company to learn about the sexual orientation? I don't know. Depends, of course, on the purposes of the company, but those are the questions that a company should ask themselves before they go into asking that type of information, especially, as I said in the previous case, right? Ethnicity, sexual orientation, they are sensitive personal data. So the threshold to receive, to obtain, to request this kind of information is quite a bit higher than when we talk about not sensitive personal data. Another one that I see here is problematic is also the lawfulness, right? Which legal basis is used? And it's the problem here is a bit twofold. We talk about sensitive personal data. So typically we would go for consent. Typically consent would be the strongest legal basis to receive this kind of sensitive data. But for consent to be valid, consent needs to be freely given, right? A person who gives consent must be able to say, I don't want to give my consent and I won't have any negative consequences. This person cannot have any negative consequences for not giving consent, because otherwise it's not freely given. You're obliged to give your consent and then it's not valid. And it's actually considered in a employee-employer situation. It's often argued that there is actually a power imbalance between the employer and the employee, right? The employer is basically is paying the employee for the work, and so there's a power imbalance. And so it's often argued that in an employment context, consent cannot be valid because an employee cannot give their consent freely. They are usually forced, not necessarily forced, but it's not easy for an employee not to give their consent if it's requested. So a valid consent is actually quite difficult to prove in a situation of employment. In some countries, though, what's important to know, companies are obliged to collect certain employee diversity information. So in that case, of course, the information that companies are required to obtain by the law is then there's a legal obligation for those companies to do this. So that would then be their legal basis. So that's something they can use. And in certain cases, you could also work with legitimate interest as a legal basis. But with legitimate interest, it is important that the benefit the processing gives to the company is not overpowering or not in disbalance with the impact it has on the person, on the privacy of the person who the data is asked from. So, legal basis in this case is a bit of a tough one, not impossible, but it's definitely something the company should think about, how to put this in place and how to have this employee diversity monitoring, how it will be done. A few measures that can be implemented, right, to lower the impact on the data subject and lower basically also the risk for the company. is to make sure that the monitoring or the queries, the surveys that are sent out to the employees, the answers to those are fully voluntarily. So people are fully free to answer yes or no. There's no negative consequence if the person decides not to fill it in. You can also ensure that every question in your survey can or cannot be filled in, so that none of the questions are mandatory to be filled in. Again, making sure that this information is given fully voluntarily. And if possible, obviously, if you can send the surveys without asking the person's name or position, make it as anonymous as possible. That's definitely also something which would be recommended. A few of you said confidentiality is a potential problem. Indeed, it could be, because they say there are concerns about how the data is stored and used. That's indeed also something that could potentially be problematic, right? Is this if these surveys are if this information is gathered from the employees, it's important that you really make sure that only the people who need to know this information also receive access to this information. So you really have to limit the access to specifically, one person within the HR team, and then one person potentially like in a management position, or make sure that there's no need to give access to the entire HR department, let's say. So that's indeed also a good answer. Purpose limitation, indeed, also for this last sentence, concerns about how it's stored and used. Purpose limitation, it would be important to make sure really that all the information that is gathered really is only used in the context of this monitoring, in the context of this employee diversity, and for nothing else. So indeed, that's also something that a company would have to keep in mind. The real life case we're talking about happened in Spain, where a child, it's not an employee situation, but also when it comes to it, it's also a diversity monitoring case. So in Spain, a school child was asked to fill out a survey in class about quite some intimate family and personal issues. The child went home to his parents and explained to the parent what it needed to fill in the surveys. The parents did not agree with this. That basically there was too much information, too sensitive information, also too personal information that was requested by the school. They went to the school, complained about it, and the school said that the purpose of the surveys was to guide and inform the schools and the families about the level of education acquired by the school's children. And their explanation was basically that they needed to have this background information about the specific child, to basically be able to give a context to the level of education and the results that they found in their research in following the surveys. The parents did not agree with this. They went to the Spanish Data Protection Authority, the APD, and the APT decided that the personal data that was collected was not necessary for that purpose in question, and so the school had to stop asking these questions in the context of the survey. So, highlighting the fact that indeed, data minimization is important. Think about which information do we need to obtain the purpose, to obtain the results we want to obtain, and don't ask anything else. And if possible, stay away from sensitive personal data. That's really something I would try to avoid as much as possible. All right. Case number 3. Equal work, equal pay. Obviously also very important in a DUI situation. So what was going on? Was a scenario: a multinational company aims to promote pay equity across its global workforce as part of its DEI initiative. To address the gender pay gap, the company creates a pay transparency platform where employees can view salary ranges for different roles. However, a group of employees filed a complaint claiming the platform does not respect the confidentiality of their personal data. I'll go back to the key principles. Which ones do you think are potentially problematic in this situation? Scenario, yes. Here we are. Oh, sorry. Mm-hmm. Integrity and confidentiality. Anyone else want to share? What do you think? Confidentiality, okay. GDPR principles, yes. Here we are. All right. Confidentiality, integrity, confidentiality, purpose limitation, fairness. Okay. Okay. So confidentiality is indeed what you would what seems like to be the most logical one. I'm going to end with that one because it's going to bring us straight to the real life cases. Transparency is indeed transparency is like the number one thing. Usually you have to really make sure whatever you do in a company, you have to make sure people know what to expect. People need to know what you're doing with their data, whether it's within an HR situation within your company or also when you talk to your customers. You always have to make sure that they know what you're doing. So transparency is for me always the number one thing. I will check whether a company has been transparent on what they are doing. I'll quickly read the message here. Firstly, why companies asking these information from their own employees? They just don't show the statistics inform fulfilling confidentiality and other requirements. Yes, good points. Indeed, that's definitely that would be a good solution. And this touches upon the next one, which for me would be a problem, or for me would be how do you say this? Like a something to watch out for, a red flag kind of, is data minimization, right? Why don't they just show the statistics? Why do they need to really give all this information on really who earns what? Um, uh, yeah, who earns what? Is it really necessary to have this level of information, this level of detail, really? Or can you just make sure that you indeed show some statistics fulfilling the requirement of data minimization, but then as well, indeed, making sure that the data is held more confidentially? What other answers do we see here? Purpose limitation, indeed. Purpose limitation, it's important to make sure, again, all the information that is obtained, make sure that it stays within, or that is only used within this context and it cannot be used in any other context. So that's definitely important, making sure that this information sticks to the purpose for which it was achieved. Yeah, so those are the most important ones. I think transparency, data minimization, lawfulness, you could say that this is lawfulness. Well, soon there is actually going to be a directive in Europe that is going to oblige companies to divulge or to make public certain information on their salary. So in that case, actually, the company could use as a legal basis the legal obligation. But lawfulness, I think, in this case, companies would have a reasonable legal basis or reason why they would want to do this. But talking about transparency, because that's for me, this one is a bit the most obvious one. You might think that indeed the employees claiming that their data is not held confidentially, that they have a point, because indeed there is not really a need for everyone to have an understanding of who is earning what, right? I understand, like, this is it makes sense that this is what they say. However, we have seen there are two real life cases which look at it from a different angle and which actually do not agree with this. We'll start with the one that was decided by the Supreme Court in France in 2023. In this case, the complainant was a former employee of a company who was dismissed. And after that dismissal, she filed a complaint at a labor court in France, saying that her male colleagues who occupied the same job earned a higher salary than her. The courts obliged, or the lady, the lady, she asked to understand, to have insights into these salaries of these men. They went into court. The court obliged the company to present the payrolls of 8 male employees, which would expose all this information, right? Which would show all the information on really name, surname, how much they earn. So it was very detailed. The court obliged a very detailed report on the income or on the salary of these male employees on occupying the same job as the female former employee. The company appealed the decision at the labor court. The company said that the disclosure would not be compliant with GDPR, amongst others, on the principles of purpose limitation, indeed, and confidentiality, saying that doesn't serve the purpose for which the information was initially processed, and indeed confidentiality of the salary information. The case went to the Supreme Court, which then reminded that the right to privacy is not an absolute right. And meaning that when it comes in conflict with another fundamental right, such as in this case, the right of non-discrimination and equality, the two fundamental rights need to be balanced. So this is, for me, it's quite a special case, because it's they're saying GDPR is important, but there's not just GDPR. There's also other fundamental rights, and we have to take into account all of them. And so the Supreme Court considered that the disclosure of the information was essential to the exercise of the rights of the complainant, the right of non-discrimination and equality. And so that the right of privacy was less important, or was less important basically than this right of non-discrimination. And so the courts ordered the disclosure of this information, and so the company needed to provide the information. So it really shows that privacy and GDPR is not end all be all, right? It still always needs to be put in the context of the other fundamental rights. And the second case is from the Court of Appeal in Coimbra in Portugal. The facts are very similar. Also, someone who was dismissed and who said that he was earning less than other people occupying the same job. And so this is I already told you basically what the really interesting part about this case is for me. In this case, it concerned a man who filed a complaint and requested the pay slips of other employees from the employer. So this highlights that it's not only about the gender gap in terms of in terms of salaries, but it's also within the same gender. So that's it's important to notice. For me, that was those were two really interesting cases. Personally, I found. We have two more cases. We'll see if we have. Val, how much time do you want to keep for the questions? You're mute. We cannot hear you.
Yeah, I think like some 10 minutes. I think that would be all right.
Yeah.
Yeah, just maybe if you can wrap up in the next 5 minutes.
Mm-hmm.
Yeah.
Very well.
You have 1 hour. Of course, we started at least later, but yeah.
Okay. No, sounds good. Sounds good. So then we'll go a bit quicker through the two last ones. So what's happening in this one? Fitness app aims to improve inclusivity by allowing the users to identify their gender beyond the binary categories of male and female. The app collects gender identity and other sensitive health-related data. And the problem is that the app is not clearly informing users about how this data is processed or stored. And so this is really an example of a good initiative, right? Trying to really do the right thing. But even if you have good intentions, you still need to fulfill the requirements of GDPR. I'll because we need to go a bit faster, I will just go through the topics which I see as problematic. But feel free to still share what you think is problematic here. Thanks for your feedback on the fact that the cases are interesting. That definitely makes me happy that this is interesting for everyone. So what's the problem here for me? Transparency again. I said it right. The first thing you need to check: do we have necessary transparency? Does everyone know? Does everyone know what's happening? And when it comes to transparency, a tip I usually give, which I think is really helpful when you think about it, is always put yourself in the shoes of the data subject, right? Let's say you're the builder of the app. Imagine you're building this app. When you're building it, then always think about, okay, I'm the user. Would I feel comfortable with the way in which the company is processing my data? Would I understand from the privacy policy that is written here? Would I understand what's actually going to happen to my data? So always put yourself in the shoes of the data subject, and that's really going to help you with this transparency obligation, understanding how to communicate this information with your data subjects. That's when it comes to transparency, very important. Another topic here is again lawfulness. Make sure that you have a correct legal basis. There's gender identity. As I mentioned, gender is not specifically mentioned as sensitive data. But when we talk about gender identity, it can already give an indication of sexual preference, which on itself is sensitive data. So the line between gender identity, it's quite thin. And so yeah, for this kind of information, also the case says, right, there's also sensitive health information. You need technically you need consent. And so this is important that you obtain consent. Another one is storage limitation. Make sure, right, that your data is stored, that you don't keep any data longer than is necessary. And then also the integrity. If you have an app collecting this type of information, your level of security should really be should follow really the sensitivity of the data that you have. So that's something you have to keep in mind when you talk about security measures, how we were going to protect our data. Also take into account the type of information that you are processing, because your level of security needs to follow the level of sensitivity. Yeah. So that's for case 4. And then we have our last case. This is a bit of a shorter one because here's mainly one problem. So we have the internal employee network. An organization creates an internal LGBTQ plus network and uses an email list to invite employees to join. But unfortunately, the HR department accidentally emails the entire staff, revealing the participants' names. As I mentioned in the beginning, data breaches happen very easily, very often, much more often than we would think. And I think, what was the number? I think 80% of the times they happen due to a human mistake. There's no shame around it. It can happen to anyone and everyone, literally, but it's just the fact. That's what happens. So that's really something on which is really important to make sure that you are really training the people who are dealing with sensitive information. Make sure that they understand how to protect this. Make sure also that everyone knows what it means to have a data breach. This is a data breach. Now we go a bit out of the principle, but when you have a data breach, in certain situations, you have an obligation to inform authorities. You have an obligation to inform the people whose data was breached. So it's important that the people who are dealing with information, with data, that they also know how to recognize the data breach and what to do in case one happens. That's important. But going back to the principles, the most important ones here are the security measures, right? That's I touched upon it. The HR department emails the entire staff. If you have proper security measures, it could be avoided. You could have rules in mailboxes. You could have, pop-ups saying, "Is this really the people you want to send this to?" It's all possible, but it needs to be installed. So the security measures should be upped in this case. And apart from that, obviously, there's a breach of confidentiality. Data is shared. Data is shared. Sensitive data is shared with people who were not supposed or who were not required to know this information. So those are the two topics in this case, which are really problematic. That was for the cases. We have one last slide with a few practical tips and tricks. The first tip I can give you is stay informed. Make sure to keep up to date with all relevant legislation, because there's GDPR. That's one thing. But now there's also the AI Act, which obliges companies to certain obligations, to certain requirements when they're using AI. There are also labor laws. As I mentioned, there's going to be this directive that obliges you to divulge or obliges companies to publish certain salary ranges. It's important to keep up to date with it. It changes so fast, so often, that that's really important. Less is more. Really make sure to only collect what's necessary for your goals. Don't ask anything else. Try to stay away from sensitive data and really focus on what do we want to achieve and what is required for this and nothing else. Provide training. Make sure that the staff that has personal data that is involved in your EDI initiative, make sure that they are trained, that they understand how to process data, how to deal with this, how to protect it. I mentioned it, how to act in case of a data breach. They happen, it's fine, but just know that they know how to deal with it. And then the main one, I mentioned it, I think, in every slide, ensure transparency. Make sure that everyone knows what you're doing. Be transparent about it. Make sure also that your privacy policy is easily readable. People need to be able to understand it. Meaning that, for example, if you work with children, if your product, your company, your service, whatever is targeted towards children, then you also have to write it in a language that they can also understand. So really, the readability is really important. And also make sure that it's easily accessible. So put it at the bottom of your website. Don't try to hide it. Make sure that if people want to have access to your privacy policy, if people want to read it, they can do it. They can easily find it. That's my final tip for you today. So thank you very much, everyone. And yeah, if you have any questions, we still have a few minutes left over for you to ask anything. Or you're also welcome to email me on my email address afterwards.
Yeah, thank you, Anne-Michèle, for an engaging presentation about the intersection of GDPR principles like fairness and transparency with EDI. And also the case studies that you presented, such as AI in recruitment, diversity monitoring. I think we also discussed pay, gender pay equality, right, inclusive product design, and also the last one with the email breach. Yeah, they clearly illustrate the challenges that organizations face these days in navigating these areas. Also, the last slide with the tips that you shared, I think, are very valuable guidance to help our participants to also better understand and address these complex issues. And I would love to open a question round, however, a short one. If someone has any questions, please feel free to unmute yourself or share in the chat. Yeah, so I have here a great presentation, including relevant information and actual cases. Yeah, thank you so much for the valuable presentation parts. Yeah, I think the cases were really great because they kind of really made it kind of easy to understand the connection and correlation when you think and when you keep those GDPR principles in mind.
Great. Happy to hear.
It was a real pleasure. Here's another comment. Okay, I have a question. So you discussed and presented all the cases. My question then, how can organization reach a balance between kind of the need for collecting the sensitive data to support the ADI goals and also staying GDPR compliant? What steps concrete steps they should take to enable this?
Yeah. So for me, it's really important to make sure that you only collect what you need. And especially when it comes to sensitive information, companies don't need that much sensitive information typically. Sometimes they do, and then you would really have to look at every use case. See, do we have a legal basis? Is there maybe a legal obligation? Are we required to have this type of information? But so I would really, in that case, look at the sensitive information and really question yourself on every type of sensitive information. Do we really need this? Do we have a legal basis? Are people aware of this? So that's what I would do to balance it out. As long as you stay away from the sensitive information, it's much easier. The threshold is much lower. You still have to follow the rules, obviously. I'm not saying that you don't have to follow the rules, but it's easier. So I would try to stay away as much as possible from sensitive information, and then if there is a need, then really look at topic per topic or type of data per type of data to see how to justify this.
I have here another comment which kind of highlights what you just said. I think there is no need to collect sensitive information, just to take care these issues are considered and taken care in the company. Yes, absolutely. So my question is, do a company that needs kind of GDPR, I don't know, person, expert, have to hire someone?
I mean, this is my job, so I'm going to say yes, of course, every company needs it. But okay, more practically, I still think yes, in the sense, especially, I do think so. Yeah, it's important to have someone who knows something about it, because a company needs to fulfill, if a company is located in Europe, or if a company is located outside of Europe but targeting the European market, you need to fulfill GDPR. And this is not only when it comes to your employees, but also to your customers, right? And there are important requirements, and there are potentially very high fines that can, that can be inflicted on companies. So I do really believe that it's important for a company to have someone, whether it's in-house or external, right? Because not every company needs to have someone in-house, but at least that they have a consultant, like on a phone call away, that they can ask questions. Because I think a lot of companies are just doing, they're copy pasting from what they see other companies doing, and that's really risky, because a lot of the times those other companies may also not have had legal counsel to help them with these topics. So they might be copying wrong things, and on top of it, it's not applied to their specific situation. So I find that risky personally. So yeah, actually, I would say it is really in the benefit of the company to have someone on call who they can ask questions from, and to have like an annual audit. With a lot of my clients, for example, I just once per year we sit together, we go through everything they do, we organize everything, and that's it. Then you don't have to do this every day. Just make sure that your processes are all updated.
Right.
I mean, that's important. Yeah, absolutely.
Yeah. There's another comment from participants. I'm going to read it out. Normally, HR takes care of these issues considering their own personnel. Only really large companies may have own persons for these matters.
It depends, because indeed HR often takes care of these issues considering their personnel, but there's not just the employees. There's also all the data processing from customers, even suppliers as well. So the personnel is only one topic when it comes to GDPR. GDPR covers any type of processing of personal data. So anything a company receives in terms of personal data needs to be compliant with GDPR, basically. So yeah. That's I work with a lot of startups as well, and it's really interesting to really start from the beginning, help them with the product development, because products also need to be GDPR compliant. So it's not even just not just the confidentiality or the transparency. It goes further than that. So GDPR is it's an important topic in every company, whether it's a small one or a big one, really.
Right. Okay. Yeah. Yeah. Absolutely. Absolutely. Any burning question to our expert? No, I think we're good to go. Yeah, yeah, and definitely thank you. Those again, I would love to highlight the cases that you brought up. Yeah, and how you connected it with those principles made for participants way more easy to kind of understand how it all works, where you need to pay attention to. Yeah, so it was very, very valuable. Thank you so much for your time and for your experience. And yeah, so we keep in touch, and all the good for the participants to completing. I think the last block, right? The last section of the online courses. Yeah.
Thanks so much. It was a pleasure.
And thank you. Thank you all. Take care.
Thank you. Have a good day.
Thank you all. Bye-bye.
Bye-bye.
Bye.
Bye.